Estate taxes, as I mentioned before, estate taxes have been changing in the last couple of years. And what I've outlined for you here is just a current structure of the estate taxes for both federal and New Jersey. Unfortunately, as residents here in New Jersey, we have two estate taxes that we have to contend with. The first one is the federal estate tax, which obviously applies to any state in the United States. And back in 2010, the unified credit, which is essentially the amount that every individual has the ability to pass tax-free at their death, was increased to $5 million. All right, so the federal estate tax right now does not apply to anybody unless their assets exceed $5 million. So according to recent news reports, it applies to Mitt Romney. But anyone under $5 million does not have a federal estate tax problem. The federal estate tax is indexed for inflation, which means that that $5 million for 2012 was increased to $5,120,000. All right. In true congressional style, this provision only lasts for 2 years. So it was enacted in the end of 2010, and Congress says that it applies until the end of 2012. All right. So this is the last year for that tax act. And if Congress does nothing, which they're pretty good at doing, on January 1, 2013, the amount goes back to what it was in 2001, which is $1 million. All right, so again, if Congress does not act in 2013, the federal estate tax will apply to anybody who has assets exceeding $1 million. All right. Any questions on the federal estate tax at all? All right. The marital deduction is unlimited, all right? As long as your spouse is a U.S. citizen, you can leave unlimited wealth, give unlimited wealth, or leave unlimited wealth to your spouse at the time that you pass away or during lifetime, all right? So if you leave all of your assets to your U.S. citizen spouse, there should not be any estate tax due at your death, all right? Portability versus credit shelter trust. I don't know if anybody's ever heard the term credit shelter trust or bypass trust, but it's a technique that's often employed in estate planning to make sure that any husband and wife can double up their exemption amount. So in other words, if a husband and wife had $10 million of assets that they wanted to leave to their children, their wills must be set up so that when one spouse passes away, not everything is left to the surviving spouse. So in that example, if husband and wife each have $5 million and husband passes away and leaves everything to wife, wife now has an estate of $10 million. If she passes away the next day, there'd be a federal estate tax on everything over $5 million. So essentially in that circumstance, we've wasted the $5 million exemption that the first spouse who passed away could have left to the kids. So credit shelter trust is an estate planning technique that's often employed to make sure that when one spouse passes away, the entirety of the estate does not end up in the estate of the surviving spouse. All right. So again, this technique for federal purposes is important if your combined assets for a husband and wife exceed $5 million. All right. Portability is a new concept that was introduced in 2010 in this last tax act. And essentially what it's done on the federal level is allowed a spouse to die without a credit shelter trust. All right. And if a spouse does not use their exemption at the time that they pass away, their surviving spouse can use that exemption at the time the surviving spouse passes away. All right. Provided, however, that the surviving spouse does not get married again during their remaining lifetime. All right. If they get married during their remaining lifetime, they get the exemption from the newer spouse, right? They lose the exemption from their first deceased spouse, all right? So it's a concept that was introduced, again, on the federal level to prevent the loss of any credit that could occur when one spouse passes away, all right? And that's why I put in there portability versus credit shelter trust. Both of those techniques are available to make sure that for a husband and wife, we can maximize the double deduction that they can pass down to the next generation. The New Jersey estate tax right now taxes estates that exceed $675,000. So obviously that's the tax that affects most of our clients, right? The threshold is a lot lower for New Jersey purposes, and it's been in place since 2001, all right? So New Jersey never had its own estate tax until 2001, and they employed it in 2001 at a level of $675,000, and they established a tax rate of 11 to 15% for assets that exceed $675,000. So again, for a husband and wife, we are able to double up the deduction of $675,000 to make a combined $1,350,000 pass down to the next generation without New Jersey estate taxes. The downside for New Jersey purposes is that portability is not available, all right? Meaning that you have to do planning in your estate if you want to ensure that both spouses' tax credits are available for use to the next generation if something happens to one spouse, all right? So again, for New Jersey purposes, the threshold is a lot lower, $675,000. The assets that New Jersey considers part of your taxable estate are the same for federal purposes: life insurance proceeds, real estate, stocks, bonds, mutual funds, all right? And again, the important thing for New Jersey, portability not available, so you want to make sure that if you do, as a husband and wife, have assets that exceed $675,000, you do planning that may include a credit shelter trust, all right?
Excuse me?
Sure.
What determines whether a person is a resident of New Jersey?
It's a good
They move the day before they die, or?
Domicile is an intent, all right? So if your intention was to make this other jurisdiction your domicile, your estate may have to establish to the state of New Jersey that you intended to make that state your domicile. New Jersey will consider you a resident here or domiciled here if you spend 6 months in a day here. All right, so we do have a lot of clients who, you know, have a place here in New Jersey, maybe a place down in Florida, and they choose Florida as a domicile because Florida does not have an estate tax at all. So residents of Florida are only subject to the federal estate tax. But if you spend more than 6 months in a day here, New Jersey is going to try and tax your estate when you pass away. All right, so.
Here, living here, renting or owning, or?
Yeah, 6 months in a day here, whether you own something or you rent here. All right, so it's an important, I think, New Jersey, because of the recent estate tax. Like I said, it's only been in place for 2001. They're going to start to audit a lot of these estates that do not file as New Jersey residents and choose a different jurisdiction if they think that they can prove that somebody was here for more than 6 months in a day. All right, and you'd be surprised, I think, how they'd be able to establish that. I think all of our movements are pretty much tracked through EasyPass credit card receipts, ATM receipts, so I think New Jersey is gearing up for some big battles on the estate tax end because it is 11%. On every $1 million is $33,000. So New Jersey is probably biding its time waiting for that big estate, you know, to pass away, and then they'll go in and try and establish that that person was here more than 6 months in a day.